So welcome Black Belt family to Black Belt Secrets, sister channel to Black Belt Barrister. So I've promised that I'm going to go through some questions in a more informal style here. If anyone has any more questions that you'd like to see in future vlog style videos, drop them in the comments and I'll get to them as soon as I can. I'm quite excited. I've just finished recording some responses to some of your questions. I'm going to need some coffee, so let's get started. With that said, the first question here is, what advice would you give to someone starting the bar course? Now that's a really common question and a really interesting question because the bar course is something really special. It is a very, very intense course. You can do it over a longer period of time, but I think that generally is 9 months. Certainly I did it in 9 months. So the most important thing I can say about it is that it's really intense. So you need to focus your efforts in the right way. So in order to get through all of the material, you have to have a structured approach. And there's no time for falling behind. So you're not allowed to get ill, you're not allowed to take time off, you're not allowed to go on holiday, all of these sorts of things, because if you do any of that whilst you are on the bar course, you're going to fall behind. Now, I've known people that went on holiday whilst they were doing the bar course and regretted it because they switched off from it and realized how much that they could have used that time to recap the materials and embed all the knowledge and the facts into their head. So that's probably the most important thing I can say. The second thing I would say is take yourself out of the academic mindset for a moment because it's a vocational course. It's a course that's designed to make you ready, not even necessarily for practice, but for pupillage. And pupillage is the last stage before actually practicing. So the course itself is giving you the approach and the skills necessary. So take yourself out of an academic framework and think of it in real life scenarios. Let me give you an example. So the notoriously difficult civil litigation exam, that's not to say criminal litigation is easy, but civil litigation is known to be the big exam. If you think of it purely in a sense of which dates and which time frames and which rules apply, you may struggle to remember it all. However, if you think of every single case and question in mind, that's a point you need to think about all your learning. You need to think about it in terms of the questions that you will get at the end. That's why BPP was excellent for me because on every single session we had practice questions. And those practice questions, if you thought about it in the right way, allowed you to think of a real life scenario and apply the rules, the time frames and everything else to a real life scenario. Too many people that I came across didn't think of this in a real life scenario and found it difficult to remember everything. But as with most things, it should make sense. So the rules should apply to real life scenarios. So those are my top tips for someone starting the bar course. Leading on nicely from that, I suppose, is any tips for those starting their LLB this September, especially in regards to essay writing and reading lists. So contrary to what I said about the bar course, the LLB is definitely academic. It's academic in nature, it's academic in analysis. I'm not saying there isn't an essence of reality that enshrines the whole of the law, but for the LLB, it has to be a very strict academic application. And most advice that we write as barristers, to link the two courses together, most advice that we write is an academic structure based on the facts and based on the law and applying the law to the facts. For the LLB, and in particular to essay writing, essentially the best phrase that I once heard was say what you're going to say it and explore it, and then summarize what you've said. So that's generally the best structure for an essay. The other thing I would say is writing an essay, everything that you say, every line, every word counts. Another tutor of mine once said, if you're going to write something down, you're going to have a very strict word count. And I think the word count was the most difficult thing to cope with on the degree course, because you might have 3,000 or 5,000 words, but believe me, by the time you get to the end, it doesn't seem like a lot of words. And if you're reluctant to cut things out, you may not put things in that are essential, and therefore you won't get as good a grade. So anything that you write absolutely must have a meaning and a purpose, and you should be able to support it in one way or another. So that's why it's a bit more academic. You need to be able to reference where the thought came from, where the rule came from, and where the application came from, and very much rest your decisions, rest your principles on the academic sources that you find and the arguments that you make. The next question reads, your thoughts on section 127 of the Communications Act, chances of it being repealed. For everyone else, you don't need to look it up. Section 127 of the Communications Act 2003 broadly makes it an offence for someone to send by means of a public electronic communication network a message or other matter that's grossly offensive or of an indecent, obscene or menacing character. So in other words, it's making it an offence to send somebody an offensive message. Now my thoughts on this are that we all live in a civil society, and as you'll probably pick up from my other videos, I think everybody should have a civil manner with each other. You know, unless someone is being attacked and then you are required to use force in self-defense and things like this, obviously those situations are different. But otherwise, sending a message that is designed to be grossly offensive or to cause offense, inconvenience, needless anxiety. The words are key for me here. Needless anxiety to another. If you're sending a message that is causing needless anxiety to another person, then by the very definition of it, there was no need to send the message. So if I've got a dispute with another person and I want to resolve it, then I can deal with that in a civil way. I can write a polite letter. I can say, this that's happening is unacceptable. Please stop doing it. If you don't stop doing it, there might be legal consequences, and so on and so on. Whereas if I were to send a message threatening, then that's obviously a completely different scenario, isn't it? So my thoughts on that are that there has to be something in place that prevents certainly the most serious of these incidents, but also catches any situations where there simply isn't anywhere else in law that this can be properly dealt with. And chances of it being repealed, probably not. There might be amendments to it, as they are very, very frequently amendments. Lots of people think that once an act of legislation is there, that's it, it's solid law. But very often amendments are made, words are switched out, sometimes entire sections of an act are repealed. So you may have an act of parliament where there's only one or two sections that are left and the rest has been repealed and replaced. But chances of it being repealed, probably not, I would say, but there might be amendments to it. They may change the wording here and there. Next question, how exactly do you find out the ownership of details, including contact details of the owner of land adjacent to a property? So this is a situation, very often there are strips and bits of land that somebody owns but doesn't have anything to do with. Very often this can be a local authority. There could be a strip of land that's beside the highway. Sometimes the local authority owns it, sometimes they don't. If they own it but don't maintain it and don't want to maintain it, they might just not have any claim to it, not lay any claim to it. Often there'll be strips of land beside a house. A good tip to look for these would be corner plot properties, because if you think about when there's a piece of land that a developer buys to then build houses on, but you get to the corner, so the corner house, there might be a big strip of land, they can't fit another house on that corner, but they can't really do anything else with that bit of land on the corner, but the developer owns the land. Then the house on the corner, obviously is next to this bit of land, might well start mowing the lawn and maintaining the land and treating it as their own. I've got a video on adverse possession over on Black Belt Barrister. So very often there'll be strips of land that belong to the developer, but the developer's long gone, has no further interest in the houses and the land and everything else. So strictly speaking, that bit of land might belong to the developer, but you're not likely to find any record of it because the houses will have been transferred to each individual owner. And unless you look back at the original title for the overall piece of land, you might struggle to find it. So the first port of call would be to write to local authorities to see whether they lay claim to the land. If you can try to dig up the original developer owner of the land and see whether they lay any claim to it. But my guess would be, if you're looking at a bit of land there, you probably want to think about your potential for adverse possession, as opposed to necessarily looking up the landowner if they're long gone and have no interest in it. Next question is, separated from wife for 7 years, no child custody issues, no property or possession issues. What does it take to divorce and how much does it cost? And finally, what is a clean break agreement and is it necessary and advisable? So several questions in one there. Now, certainly speaking for England and Wales, there's often a case of desertion, which is 5 years, but you still need to make reasonable efforts to put the other party on notice. But otherwise, for that sort of time frame, 2 years plus agreement from both parties is usually enough. And in other cases, 5 years of separation is usually enough as well. This is something you can probably do yourself. The forms are not too complicated, but if you've got any concerns about it, you can go to a solicitor or even a barrister to assist you in doing that. But it shouldn't really cost very much because it's a very simple process, so don't expect to pay many thousands of pounds for it if there really are no complications in that scenario. As for a clean break agreement, it is what it sounds. It effectively separates the two parties in any kind of financial connection or any other kind of connection for life is the term. It usually incorporates an assessment of finances, pensions and all of that. But obviously it can get a lot more complicated. But on the bare facts that you've set out, that's probably good enough to answer your question. This next one's a bit sad. My ex has stolen my dog and I'm heartbroken and told that it could cost me up to £25,000 to get him back. The cost, I don't know where you've been quoted that cost from, but if you've been quoted that cost because of going to court for maybe a declaration that the dog is yours, for example, then it wouldn't be what we call a money-only claim. You'd be claiming something else. So it's not likely that it's going to be allocated to the small claims track. It's likely there's going to be lots of conflicting witness statements and evidence as to an argument as to who the dog belongs to. There is perhaps a strategic option of claiming the amount that you contributed to the purchase of the dog. I know that doesn't get the dog back, but if the other person is only keeping the dog out of spite, then perhaps if you were to claim money against that person, they may feel that it's better to give the dog back. But all of these situations turn on their own facts, and it really does depend what extent you want to go to get a court to intervene in this situation. The next question is on private prosecutions, how to make one and what are the checks and balances. Now, any person can bring a private prosecution so long as a magistrate agrees that there's sufficient cause within the information that the person lays before the magistrate to start a private prosecution. The checks and balances, I suppose, are that the CPS, the Crown Prosecution Service, have the authority to take over any private prosecution and either continue to run it themselves or take it over and shut it down. So this has happened a lot lately in the news. CPS have taken over private prosecutions and shut them down. One might argue that there is wasted costs in this process, but whilst the system allows any person to bring a prosecution if there's enough information, it also allows the CPS to shut down a prosecution, for example, if it's not in the public interest. Now, this question is what you're allowed to do if someone is committing an offence. So I did a video on citizen's arrest over on Black Belt Barrister, but broadly speaking, any person can arrest by way of citizen's arrest another person if they are committing, or you reasonably believe they are committing, an indictable offence. And in doing so, you can only use reasonable force. So the force used must be reasonable and proportionate to what's happening at the time. It doesn't just allow you to cause injury to that person to prevent them escaping and things like that. But I would always advise caution, because if you go too far, you could be prosecuted yourself for causing any kind of harm, even if that's only a Section 47 actual bodily harm assault. You could then end up with a criminal record if you've crossed that line of reasonableness. So I would advise extreme caution if you choose to carry out a citizen's arrest. In most circumstances, I would say stand back, watch, and call the police. And for the next question, is there any law firm willing to sue social services in Scotland? First of all, there is a difference with Scotland and England and Wales. I cannot practice in Scotland. I'm authorised in England and Wales, for example. It depends what you want to sue the local authority for. Local authorities can and very often are sued, as is the government, as is any corporation. So I would just defer you to go and speak to some firms, tell them what the problem is, and ultimately a local law firm in Scotland should be able to assist you. The next question is, are defence solicitors really there to defend or just strike deals to secure their own standing, with the client's defence being secondary to that? Now, solicitors and barristers must at all times act in the best interests of the client. This may very well be advising a client to plead not guilty because the instructions are that they didn't do it, but at the same time advising on the strength of the evidence and the prospects of a prosecution and the idea that they may have a reduced sentence if they plead guilty early, and that if offered an alternative charge, that might be more favourable than going to trial. But all of the while, it's a careful balancing act, because if the client tells you that they didn't commit this offence, or that they weren't there, or anything else, that their firm instructions to you are that they didn't do it, they're not guilty, then you must advise a not guilty plea, but at the same time as advising all of that. So it can be very difficult. So I can understand how it can appear very complex, and it can appear that deals are done, so to speak, with defendants that are on trial, but ultimately that's the very complex nature of what's going on behind the scenes. And finally, this question is on the murder anomaly. In other words, why is it that you require intent to kill for attempted murder? Now, I suppose the simplest way of explaining this is that you cannot accidentally attempt to murder somebody. So I hope that makes sense. Whereas if you've intentionally caused serious bodily harm to somebody, and you're originally charged with Section 18, which is grievous bodily harm with intent, so you have intentionally harmed somebody seriously, and then let's say that person dies. Now, because you intentionally caused very serious harm and the person died, you have in fact then killed somebody, because your serious injury to that person has resulted in the person dying. That's why it can then become murder, because you've actually killed somebody. Unlike most attempted offences, such as attempted robbery, for example. Let's say someone's attempting to rob somebody but doesn't actually manage to go through with it. It is still an attempt to commit the original offence. So with attempted murder, you cannot accidentally attempt to murder somebody, because the murder bit itself is a finite result. So I hope that makes sense. So I think that's it for the questions for today's vlog. I hope I didn't miss yours out, but if I did, I will try and come back to it next time. Leave me questions, comments for the next video. I hope you like this sister channel to go along with Black Belt Barrister. Black Belt Secrets has been around for a long time, started out with martial arts. Please do check out my other videos. I hope you like some of those too. Let me know which of my other videos you like on Black Belt Secrets, and I can do more of those. Also, if any of you watching have got a channel of your own and you want a collaboration, email me, let me know what you would like to do. I plan to do my collaboration work on the weekends when I'm a bit less busy. But in the meantime, thank you so much for watching. I hope you enjoyed today's vlog. Make sure you subscribe and come back for more. See you next time.